All right. Court will sentence you to 1 year.
Welcome back to Shazi Gavel. And y'all, this is one of those courtroom clips where you're watching someone's entire life turn upside down in real time. Because in the first few seconds, what you're about to hear is not just panic. It's pure legal confusion colliding with real consequences. This case out of Texas involves Brittany Marl Brown, and what starts as a simple plea agreement quickly turns into a moment that makes everyone in the room freeze. Here's the twist. In court, one word can change your future. Conviction, deferred adjudication, probation, jail? These aren't just legal labels. These are doors that close behind you. And what Brittany thinks she's agreeing to is not what the judge says the court is about to do. And so stay with me, because this case has family violence consequences people don't realize are permanent, custody consequences that hit like a truck, and a sentencing moment so chaotic you're going to be yelling at your screen like, wait, did she just say that? And I want you to answer this early. Have you ever signed something without fully realizing what it meant? Because that exact mistake is what makes this courtroom moment explode.
In the Bexar County Jail.
No, miss.
You said a conviction.
Oh, I thought, okay, I'm sorry. Oh my God, no.
I don't understand what's going on here.
But I'm not gonna be able to have my kids.
2023
I'm
CR
not your attorney.
0042,
So the only-
State of Texas versus Brittany Marl Brown. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
And
And are you Ms. Brown?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Brown, I'm showing you what's entitled Application for Community Supervision.
Now here's what's happening legally, and why Judge Boyd is being very precise right now. When a judge asks these questions, it's not small talk. It's a constitutional checklist. The court has to confirm Brittany understands the charge she's pleading to, the punishment range, and the rights she's giving up. Because later, if she tries to argue, I didn't know what I was signing, the court record will show the judge asked it multiple times. This is basically the courtroom version of, are you sure you want to click accept? Except the consequences aren't losing your account, it's losing your freedom. And notice something important. It's a lesser included offense. That means the state originally had something stronger or more serious in play, and they're allowing her to plead to a reduced version. So that sounds like a win, until you realize reduced doesn't mean harmless. Engagement question. Should judges slow down even more when defendants clearly look confused? Or is it on the lawyer to make sure they fully understand before they ever step into court?
Brittany Marl Brown, could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
And
are you Ms. Brown?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Brown, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it? Did you understand that the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation as a Class A misdemeanor? The range of punishment is up to 1 year in jail and up to a $4,000 fine. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to?
Ooh, this is where my eyebrows go up. Because Brittany just said the quiet part out loud, I did not understand that one. And Judge Boyd immediately shifts gears. Legally, if someone genuinely doesn't understand their rights, a plea can become invalid later. It can be argued as not knowing involuntary. That's why the judge pauses and drills down. Jury trial, cross-examination, silent. The holy trinity of criminal defense rights. But here's the drama. Brittany isn't saying, I don't understand the legal theory. She's saying she didn't even hear all of it, meaning she's overwhelmed, nervous, and probably terrified. This is the kind of defendant who says yes just to make the moment end, and that is dangerous. Also, notice how she says, I heard it, but I didn't hear. That tells me her brain is in survival mode. The courtrooms don't feel like classrooms. They feel like Judgment Day. Engagement question. If you were Brittany, would you stop everything and ask for more time? Or would you just go along because you're scared of making the judge mad?
All right, you don't understand you have a
No, I
right to
didn't.
jury trial?
I mean, I heard it, but I didn't hear it.
All right, so do you need to speak to your attorney?
No, can you please repeat the question?
Do you understand you have a right to jury trial?
Yes, I don't.
All right. Do you understand that you have a right to have your attorney cross-examine or question any witnesses the state would call?
Yes, ma'am.
Did you understand you have a right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up your right to a jury trial?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up your right to have your attorney question or cross-examine witnesses?
Yes, ma'am.
Did you understand by entering this plea, you're giving up your right to remain silent?
Yes.
And did you intend to do that and enter into a plea bargain agreement today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the Bear County Jail.
Okay, this is one of those courtroom moments that confuses the public every time. The plea says punishment assessed at 1 year in jail, but the state recommends community supervision, probation. That sounds contradictory, but it's actually common. Here's the breakdown. The sentence is what's written as the punishment range/assessment. But probation can be offered so you don't serve that time, as long as you comply. So Brittany is hearing 1 year jail and her brain is screaming, even though the state is basically saying, "Judge, let her do probation instead." But then comes the bigger problem, the affirmative finding of family violence. That isn't just a label, it's a lifelong stamp with serious collateral consequences. And this is where it stops being a misdemeanor deal and becomes a permanent life consequence. And you can already see it happening. She's reacting like she's just now learning the real costs.
During this plea, you're giving up your right to remain silent.
Yes.
And did you intend to do that and enter into a plea bargain agreement today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the Bear County Jail. State recommends community supervision. There's an affirmative finding of family violence. I'm going to need you all to be quiet in the box, please. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Tegui, Tegui, Bizu, Biezou. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
That's forever?
You're not allowed to own or possess any weapons.
You. Judge Boyd just dropped one of the biggest legal landmines in the entire case with a family violence finding, no guns, no ammo, forever. And Brittany's reaction is exactly what we see constantly. But what about protection? Because people don't understand. This isn't the judge being mean. This is federal and state consequence territory. Many jurisdictions treat family violence findings like a trigger for weapon prohibitions. And I want you to notice something. Brittany's not fighting the plea right now because she thinks she's innocent. She's fighting because she's realizing the plea doesn't just punish her today, it punishes her for life. This is why lawyers must explain collateral consequences before the plea hearing. Because once that finding is entered, it can affect firearm rights, employment opportunities, housing, and child custody decisions. Engagement question. Do you think a forever ban makes sense for every family violence case? Or should it depend on the facts and severity?
Finding of family violence. I'm going to need you all to be quiet in the box, please. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Tegui, Tegui, Bizu, Biezou. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
That's forever?
You're not allowed to own or possess any weapons or ammunition. Do you understand that?
I mean, yeah, but I can never, for protection, have.
You need to speak to your attorney about that. But with an
Okay.
affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition.
Okay.
Do you understand?
Yes, ma'am.
And with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent. Did you understand that?
This is the moment the air changes in the courtroom. Because guns, people can rationalize that. But custody, that hits the soul. Let's be clear. Judge Boyd explains this correctly. It doesn't mean Brittany can't see her kids. It means if custody becomes an issue in the future and the court has to decide primary placement, the law heavily disfavors placing the children primarily with someone who has an affirmative family violence finding. Unless there's evidence it's still in the best interest of the children. But Brittany hears it like, "You're taking my kids." And I'm gonna say something blunt. This is why defendants panic in family violence pleas. People don't realize criminal cases don't stay in criminal court. They echo into family court, CPS issues, housing, employment, everything. A Judge Boyd is actually doing something very rare here. She's slowing down and explaining what other judges don't. And still, Brittany is spiraling.
This is the first time I heard of that.
All right, so I'll let you all step back. So
So I'm no, what does that mean?
I'll let you
That
speak
I'm
to
not-
your attorney about that.
I'm not allowed to have children?
Oh, you can have children, but if there's some sort of custody issues that arise, technically and legally, the court is not allowed to have you as primary custodial parent. Now, if in the best interest of the children, they determine that you will be the best placement, then they can do that. But if there were any type of custody issues and there's a person who appears to be a good parent and they don't have an affirmative finding of family violence, then they're supposed to be designated as primary custodial parent. I'll let you speak to your attorney about it. So I'll have you all step back and you can talk to your attorney. All right, so we're back on the record. In 2023 CR 0042, Brittany Brown. We were on the plea. So did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of the plea bargain agreement? I don't understand what's going on here.
But I'm not gonna be able to have my kids?
This is a raw human moment, but it's also a dangerous courtroom moment because Brittany is now emotionally negotiating out loud in front of the record, and Judge Boyd has to stay in judge mode. I'm not your attorney. And Judge Boyd's explanation, that's actually a masterclass. She says collateral consequences, meaning side effects of the criminal case that hit you in civil life. Custody, weapons, housing, reputation. So even if the charge is reduced to a misdemeanor, the family violence finding carries heavyweight consequences. But here's what I want you to notice. Brittany keeps saying, "First time I heard of that." If that's true, her lawyer has some explaining to do. Because a plea deal without full explanation is basically handing someone a contract written in legal fire. Engagement question. Do you believe Brittany truly didn't know these consequences? Or do you think she knew and only realized how serious it felt once she heard it in open court?
I'm not your attorney. So the only thing my job is to make you understand what the plea bargain agreement is. I've explained to you with regards to the meaning of an affirmative finding of family violence, and I always give people those instructions so they will know. Because many times when people enter pleas on the criminal sides, they have an impact civilly and in other ways. So with all of these family violence cases, when there's an affirmative finding of family violence, there are certain collateral consequences. One of those is you can't have a weapon. You can't possess ammunition. That's how it is in Texas. I can't tell you how it is in other states. But you can't have weapons, you can't have ammunition, and you can't be designated as primary custodial parent. So legally, you can't be designated as primary custodial parent. Those are the consequences of entering a plea And those are the consequences of having an affirmative finding of family violence. Now, if you would like to, counsel, we can bring this back for tomorrow.
No, it's okay, fine.
All right, this is what I'm gonna do. I'm gonna have you all take a seat just to
No, ma'am,
talk it out
I do
more.
understand it, but it's just so, it's a horrible thing for, like, to have, this is horrible, so I understand it, but
I mean, all the cases here are horrible. They're felony cases.
I thought it was getting reduced.
It's still getting reduced, but it's still, all these cases have consequences. Whether it's being reduced to a misdemeanor or not, there are consequences that flow from felony cases and consequences that flow from criminal charges. So what I'm going to do is I'm going to have you sit with your attorney because I want you to, if you're planning on entering a plea in this case, I want you to enter it with a clear conscience and a clear understanding. So it appears to me, and I may be wrong, I'm making assumptions here, that you didn't know the consequences civilly of entering a plea in this case. And the fact that you're talking to me about, am I ever going to be able to possess weapons? Am I ever going to have my children? That's something that you need to discuss with your attorney, and it needs to be in a setting. I don't want to say without passion or objectively, because I know these are all personal matters, but it needs to be something that's thought about with clear head and something to think about. All right, so I'm going to have you all step back. And if your attorney feels like it's best that this be taken up tomorrow, we'll take it up tomorrow. I'm here all week. All right, so just step back and discuss it with your
I
attorney.
understand it, there's nothing I could do.
All right, just step back and talk to your record. In 2023 CR 0042, State of Texas versus Brittany Brown. So Ms. Brown, I've gone over the plea bargain agreement with you. Did you understand that to be the plea?
Yes, ma'am.
And do you understand the consequences of entering a plea with an affirmative finding of family violence? And knowing that, do you wish to proceed? All right, did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
And counsel, did you understand that to be the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be 100 hours of community service restitution, the BIPP, a TAP evaluation, and follow all recommendations from the TAP evaluation.
All right, listen carefully. This is where the courtroom starts feeling like a legal minefield. The prosecutor says outside the agreement, meaning this is not part of the official plea bargain. It's just what the state is asking the judge to do in sentencing. And Judge Boyd even confirms that the court does not have to follow those recommendations. This is huge because many defendants think if the prosecutor says it, it's guaranteed. Nope, not in court. The plea bargain locks in certain terms, but sentencing conditions? That's often still judge discretion, especially on probation-style cases. So take note of what the state wants. 2 years deferred adjudication, 100 hours community service restitution, BIPP/TAP evaluation, basically intervention plus treatment assessment. So the state isn't coming in asking to throw her under the jail. They're asking for structured supervision. But it also tells us something important. This case likely had serious concerns around behavior, stability, and compliance. Engagement question: would you trust deferred adjudication if you knew one slip-up could still land you in jail? Or would you rather take the conviction and just be done with court forever?
Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yeah.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, sir. At this time, state up for state exhibit number 1 and its attachment.
No objections, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Um, he has had the problems, I guess, communicating and understanding what is happening, but after explaining several times for the situation, um, she understands everything, and we're asking that the court accept the recommendation from the state to place on deferred.
All right, what was your warrant for? In the police report, it says that when the complainant called the police showed that you had a warrant. So what did you have an active warrant for?
It had been for a failure to ID.
All right, state, can you see if there are any pending charges other than this case?
Yeah, there's a failure to ID. Oh, sorry.
Your Honor, there's a failure to ID, and that one is for the state, would be TIC.
It's not listed in the plea.
Judge, there is, but we can, I can tender a dismissal. I think you just give me a couple notes to fill out a dismissal.
All right, thank you. All right, are you employed?
At the moment, no, I'm not.
How do you support yourself?
I'm living with family right now.
What family is this?
My mom.
All right, and Child Protective Services were called. Is Child Protective Services involved?
Yes.
All right, this is what the court is going to do. 2 years deferred adjudication.
Okay, this is the part where the courtroom turns into a chess match, and Brittany is not prepared for the rules. Judge Boyd starts to announce what she's going to do, then pauses and corrects it midstream because the state is requesting something different, a conviction instead of deferred adjudication. This matters because conviction versus deferred adjudication isn't just semantics. It's the difference between conviction equals guilty is officially entered. Deferred adjudication equals you plead, but the court defers finding guilt. And if you complete it successfully, you may avoid a final conviction on your record, depending on Texas rules and future eligibility. But here's what makes this moment explosive. Brittany is visibly overwhelmed, and the judge is now directly offering her a choice. And I love that Judge Boyd does this transparently on the record. She's basically saying, you bargained for conviction, but I have power to give you deferred. Choose carefully. This is rare courtroom clarity, and it's about to backfire in the most dramatic way possible.
There's an affirmative finding of family violence. Well, let me strike that. The state is requesting that actually you have a conviction. What the court can do is you can have a conviction. That's what you bargained for, or either I can give her deferred adjudication.
Leave it was for deferred adjudication in behalf of.
All right, if the court were to give you deferred adjudication, if anything were to happen and your probation were revoked, you could end up with potentially 1 year in the Bexar County Jail. What the state has offered you, if you were to not do well, you could still end up with 1 year in the Bexar County Jail. So which would you prefer? Would you prefer conviction or deferred adjudication?
Boom. This is the viral moment. This is the one that makes people replay the clip 5 times. Brittany says, conviction. Judge Boyd immediately responds like a judge has to respond. All right, 1 year in county jail. And Brittany's reaction? Pure panic. Oh my God, no, no, no. Now, let's explain why this happened. Brittany thought conviction meant I'm convicted, like I'm done and I go home. But in reality, conviction means the judge can impose the full sentence immediately. And the plea agreement literally said 1 year in jail assessed. Deferred adjudication is probation style. Conviction is sentencing style. She basically chose the option that puts the hammer down now. And here's the heartbreaking part. Judge Boyd didn't trap her. She asked her clearly. This is a comprehension breakdown, not a judicial ambush. Engagement question. Be honest. If you were standing there scared and confused, would you even know the difference between conviction and deferred adjudication?
Conviction.
All right, court will sentence you to 1 year in the Bear County Jail.
No, miss.
You said a conviction.
Oh, I thought, okay, I'm sorry. Oh my God, no. No.
So are you
I thought you
asking,
meant like on the record.
are you asking for deferred?
Yes, ma'am.
All right, with the deferred adjudication, the court could sentence you to up to 1 year in the Bear County Jail if you are unsuccessful. Do you understand?
Yes,
And up to a $4,000 fine. Do you understand?
yes, ma'am.
And are you requesting that the court give you deferred adjudication?
Yes,
All right. Court will sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Tagai Buzu. If there is some kind of child custody.
This is where Judge Boyd shows a mix of firmness and mercy. She doesn't mock her. She doesn't punish her for being confused. She does what a good judge does. She forces clarity on the record. Are you asking for deferred? Yes, ma'am. That's the judge basically saying, you're not about to scream later that you didn't choose this. We're getting it clear right now. And then she repeats the warning. If Brittany violates deferred adjudication, she could still get up to 1 year in jail and a fine. Judge Boyd is creating a record that Brittany understood deferred still carries major risk. This is the courtroom lesson. Deferred adjudication isn't getting away with it. It's a legal tightrope. Your freedom depends on compliance. So Brittany is getting saved from immediate jail, but she's being placed in a system where any violation could bring her right back in cuffs. And given how shaky Brittany's understanding has been, that's concerning.
All right, with the deferred adjudication, the court could sentence you to up to 1 year in the Bear County Jail if you are unsuccessful. Do you understand?
yes,
And up to a $4,000 fine. Do you understand?
yes, ma'am.
And are you requesting that the court give you deferred adjudication?
Yes,
All right. Court will sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Tagai Buzu. If there is some kind of child custody arrangements that need to be made, you'll need to make those through a third party. If you wish to have contact with him, he'll have to come in to court, and I'd have to hear some evidence with regards to that. There's to be 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination.
This section right here is where the judge lays down the real-world structure of probation. First, no contact with the complainant unless handled through third parties for custody arrangements. That's common in family violence cases. The court is trying to prevent the relationship from spiraling back into a volatile cycle. Second, 100 hours of community service and restitution. That's standard. But the vaccination credit? That's interesting. Judge Boyd is clear. She's not forcing the vaccine, but she's incentivizing it by waiving hours. That's the court using probation as a behavioral lever. Then comes the heavy stuff. TAP evaluation, BIPP course, outpatient treatment, UAs, field visits, monthly supervision. This is not light probation. This is hands-on. And the employment restriction is a bombshell. No home health care provider work or working with minors. That implies the court sees risk factors. This is one of those cases where you realize the plea isn't just punishment, it's court-managed life redesign. Engagement question. Do you think probation conditions like these actually help people rebuild? Or do they set people up to fail because the rules are too strict?
Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to request parenting classes. CPS should give you parenting classes. CPS compliance. Probation, if CPS is giving her parenting classes, then she can, then the court will accept parenting classes from CPS for her. There's to be the BIPP course. TAP evaluation. And whatever the TAP comes back with, we'll start with supportive outpatient treatment. And again, if CPS is giving her alcohol treatment or drug treatment, then CPS can do that, and that'll be acceptable. Regular UAs, I'm going to want field visits at least one time per month until further notice. Regular reporting in person or by Zoom. Proof of employment within 15 days. There should be no employment as a home health care provider or with minors. Probation, is there anything else she needs? Is there anything else you need from the court in order to be successful? Anything else you need, Ms. Brown? I can't understand that.
You said, what did you say about minors?
You're not to have any employment.
Oh, like a daycare? Okay.
Yes. And you to follow all CPS compliance rules. Did you review this document with your attorney entitled Trial Court Certification of Defendant's Rights to Appeal? Did you understand it and did you sign it? Did you review that document with your attorney?
I'm sorry.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? PS compliance rules. Did you review this document with your attorney entitled Trial Court Certification of Defendant's Rights to Appeal? Did you understand it and did you sign it? Did you review that document with your attorney?
I'm sorry.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yeah. All right, good luck to you. Court is calling 2023 CR 0042, State of Texas versus Brittany Merrill Brown for the state. Oh, no problem. No problem. And are you Brittany Brown?
Yes, ma'am.
Are you the same Brittany Brown who was placed on deferred adjudication?
And here's the consequence arc, folks. This is what I always tell people. Probation isn't freedom. It's conditional survival. Fast forward to 2024 and Brittany is back. Not for a new case, but for an alleged violation. Failing to follow TAPI treatment recommendations. And she pleads true. In probation court, true is basically saying, yes, judge, I violated the terms. That's serious because now Judge Boyd has the authority to grant the motion, find her guilty, impose jail time, impose fines. No agreement here either, meaning Brittany is standing in front of a judge with her fate wide open. And when the state requests an extension plus DDRF as recommended, that tells us probation sees her as needing structured treatment, maybe mental health, substance issues, or program compliance. And Brittany then explains she was told to get off medication to enter a program. She did, and still got denied. That's tragic because it shows how broken some systems can be. They demand stability, but the process itself creates instability. This is not a bad person moment. It's a falling through the cracks moment.
2023 CR 0042 for the offense of assault bodily injury married on February 6, 2023 for a period of 2 years. Is that you?
Yes, Your Honor.
And did you review that motion with your attorney?
Yes.
All right, state.
Your Honor, on or about the 6th day of May 2024 in Bear County, Texas, the defendant, Brittany Merrill Brown, did then and there fail to follow all TAP treatment recommendations as directed by the court and or Barrett County Community Supervision Department in violation of condition number 15.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, sentence you up to a $4,000 fine and up to 1 year in the Bear County Jail? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 15?
Yes, Your Honor.
Court will find violation of condition number 15 true. Is there a proposed agreement?
There is not, Your Honor.
All right, state, what are you requesting?
The state is requesting an extension of community supervision for 2 years and an amendment for DDRF as recommended by TAP.
All right, this is a misdemeanor case.
Your
So,
Honor, may I say something?
You want to raise your right hand?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, yes, what would you like to say?
Well, I was gonna go to the SATA program and they told me, they came and saw me and they were like, get off their medication and you can go to our program. So I got off the medication and then they still denied me. And like, I've been here since January, away from my kids, like, I was just hoping I could have another chance to do outpatient. I'm hoping for another chance, Your Honor. I'm begging for another chance.
Okay,
That's all I have to say.
all right, this is what we're gonna do. We're gonna come back at 2:30, and I'll give you my decision at that time, okay?
Yes, Your Honor.
All right, thank you.
Thank you, Judge.
We're gonna go back on the record in 2023 CR 0042, Brittany Brown. And where we left off, Ms. Brown, you had told me some issues you were having. All right. I'm not a medical doctor, but before you go off of medication, it may be best for you to contact your doctor to see if that's something you should be doing. You understand?
Yes.
All right. So on this one, she was placed on probation in 2023. I'm not going to extend her. So probation, you all are recommending on Ms. Brown, you all are recommending SATIF.
Judge, the recommendations for DDRF.
All right, DDRF. All right, and has she already been approved? There's no other,
Your Honor, I believe there was a similar issue with when she got off her medication to go to SATIF. And then the SATIF didn't accept her after that. And then I think, at least according to my client, there was an issue with DDRF not accepting her because she had gone off of her medication. So I think there was an issue on.
all right,
Both sides.
so Ms. Brown, are you currently on your medications?
No, and I haven't been able to get back on them since SATA told me to get off of them so I can go to the program. And I got off of them and they just still denied me. And then I still haven't been able to get on meds. They haven't given back to me. And I've been off since April.
All right, so here's my question. The medication you've received, who was that through?
It was through here.
All right, so probation. Can we make sure that the jail knows that she's supposed to be on medication? So that,
So it looks like the eval is for MIC supervision only,
okay,
not for inpatient.
all right. So state. That was Mr. Dunn. My understanding is the state wanted to continue her.
Yes, they were asking to continue and extend for 2 years as well as DDRF. And we were asking, we weren't opposed to the continuation or to the extension, Your Honor. We were just asking for outpatient treatment, given the circumstances with the difficulty getting into DDRF and for SATIF.
All right, and so in reading violation of condition number 15, I think the name in that violation is incorrect.
It is, Your Honor. And I discussed that with the COO, at least the main one. She was aware of that issue. Both violations that are alleged are still for Ms. Brown. I think there was just a typo in the name.
All right, so you have no objection to the oral amendment to the correct name in the violation of condition 15? All right, so Ms. Brown, have you ever been out of custody since you've had this charge?
Well, yeah,
All right, so have you been out of custody while you've been on probation before?
yes, Your Honor.
All right,
I
so,
just- I'm sorry.
no problem.
I just been here since January.
All right, so you were placed on probation and then you were out of custody, is that correct?
Yes.
All right, and my understanding, we had DDRF was not available because of her length of probation.
Correct. She would need at least 1 year remaining for DDRF.
Okay. All right, so who were you living with?
My mom.
And has anyone talked to her mom to see if her mom wants her back in the home?
I have not been in contact with the mother, Your Honor.
All right. Do you have your mother's number?
Yes.
All right, so this is what we're gonna do, because I don't want to set her up to fail. If you'll give her number to your counsel, then if you and probation can speak to her
Okay.
to see if she is okay with her going back to her home, then I'll be able to have an idea of what to do with this case.
Okay, can do that, Your Honor.
All right, thank you.
Thank you.
And probation, is drugs an issue in this case? Or I should say illegal substances?
I don't show any recent UAs, Judge.
Okay.
Probably because she had been in custody for these evaluations. The last UAs were failed to submit and a negative back in July of last year.
Okay, so what's going to end up happening, your attorney, you're going to give him your mother's number, and then the attorney in probation can speak with her. And if for some reason that's not an appropriate place for you to live, then we will figure out somewhere else for you to stay.
Thank you, Your Honor.
All right, thank you.
I'll make a call right now.
All right, thank you. Probation on this case, before we go on the record, is there a place for her or something we can do if her mother decides not to let her live with her?
I can see what housing resources we've received from our reentry specialist
Okay,
and print those out for her just so she can have for her release.
all right. And then we're going to go back on the record in 2023 CR 0042, State versus Brittany Brown. So, Ms. Brown, have you talked to your mom on the phone?
About a week ago.
All right. Did you ask her if you could stay with her? And what did she say? All right. Here's the thing. If I go on your word and allow you to live with your mom, probation is going to call. And if your mother says you can't live there, you can't live there.
Yes.
Okay. All right. So I'm going to deny the motion. Alter and amend conditions to include MIC, because I see where she is eligible for MIC, correct?
Yes, Judge.
So we'll place her on the MIC caseload. And do you have a case manager or anything of that nature with Center for Healthcare Services?
I need to get back over there on Fredericksburg to my doctor.
All right, so we're going to do a referral to Center for Healthcare Services. You're going to need to provide a release to probation. And you need to let them know who your case manager is. And you're to reside with your mother. And you're to make sure that probation has that address. Do you understand? Probation, is there anything else she needs?
The only other thing, Judge, would be if you want to order some type of outpatient component for her, the dual diagnosis outpatient.
All right, we'll do dual diagnosis outpatient. And my previous conditions will stand. And there's also to be no unsupervised contact with minors. And counsel, once she is stable on all her medications, you can always come back and change that. So for now, if you want to be around minor children, even if they're your own children, your mother or some adult that's approved by probation must be present. And that's just until you get back stabilized on your medications. You understand?
Yes, Your Honor.
Is there anything else you need from the court?
No.
All right, we can go off the record. Here's the thing. If there are issues or something's happening at your house, maybe you and your mom are not getting along, because I tell people all the time that when you live with somebody else, if you're living in their space, their rules apply. No matter how old we are and it's our mom, if they want the television off at 10, TV must be off at 10, whether you're 12 or 30. All right?
Right.
If something happens where you all get in an argument and she say you have to leave, don't just throw your hands up. If she wants you to leave, you come back to court or call your probation officer and we'll figure something out. Don't just fall off the face of the earth and then you're back in blue. You understand?
Yes, Your Honor.
All right. Good luck to you.
Thank you, Judge.
You're welcome.
All right, let's wrap this one up professionally because this case is bigger than just one chaotic courtroom moment. This started as State of Texas versus Brittany Marl Brown, reduced to a lesser included assault bodily injury case with an affirmative finding of family violence. Judge Boyd carefully explained the consequences, and we watched Brittany struggle to grasp how criminal pleas echo into civil life. Weapons bans, custody complications, and long-term restrictions. Then came the pivotal courtroom shocker. Brittany mistakenly chose conviction, immediately triggering the judge's 1-year jail sentence, followed by instant panic and reversal on the record. Judge Boyd ultimately sentenced her to 2 years deferred adjudication with heavy probation requirements. No contact orders, BIPP/TAP evaluations, treatment compliance, community service, reporting, and restrictions around working with minors. And when Brittany later violated treatment conditions, Judge Boyd took a balanced approach, denying harsher amendment requests and instead shifting her to structured support, mental health supervision, MIC caseload, referrals, dual diagnosis outpatient treatment, and stability-based safeguards like no unsupervised minor contact until medication is stabilized.